deeper in. All right. So with this, we have a presentation for you, which we will show, but I will begin with a request that all of you kindly just simply Google and download this legislation, which is known as Digital Personal Data Protection Act 2023. This DPDP Act of 2023 brings out a lot of new concepts, and we will discuss a number of examples as to how from morning till evening, in fact, today itself, you would have had several instances where you are either the data principal, or you are the data processor, or you are the data fiduciary. All right. So with this, let us begin this presentation. Parvez, my colleague, and Anshul from FADA, I will seek your help for running this presentation. Okay. So let's look at an example here. I was not feeling well a few days ago. So I got up in the morning and I went to a doctor. The doctor said that you should get a few tests done. I went to that clinic. Some of my blood samples were drawn. The other samples, which were also directed for those tests, were drawn. And pursuant to that, a substantial amount of data got generated about my health condition. It stated as to what my hemoglobin is, till what the KFT and the LFT tests have to say. What is the lipid profile looking like? What is the situation of my heart? How good is my kidney? How good are the various parameters which decide how healthy or unhealthy a person is? What is the kind of medical attention that is required? Now, you see, by this very small act of walking inside a lab or a center where you give your samples, a wealth of data gets generated, which tells not only about your well-being, but also about what medication would you require, what kind of therapy or treatment would you require over a period of time, how your next 20 years or 30 years of your life going to be. Now, anyone who has given this data, or the person who has received this data, or a person who processes this data, has now been put under a regulatory framework in this new legislation to set out as to what will be their rights and obligations. Now, the example I gave of giving a blood test today morning, now I am the person who has given the data, or who has given the sample pursuant to which the data got generated. I am known as data principal. I have given that data to a lab. Let's assume for a moment that is called a Dr. Lal Path Lab. That has become a data fiduciary in this. That data is then being processed at various ends. It is, of course, processed at the lab to generate the report, but it is also processed at various ends. For example, it is processed at the hospital from where I got referred, okay? Or it is being processed at the medical shop who's going to look at those data and give me a medication which the doctor has prescribed. Now, this legislation sets out the duties and obligations of all these players in this, okay? Now, this was just a simple example. We will get into examples which are closer to our day-to-day functioning. So therefore, my first request would be, it's a very plain and simple piece of legislation. All of you kindly simply download this Digital Personal Data Protection Act of 2023. It is set out, in fact, in a very interesting manner. For the first time in India, a legislation has been primarily drafted with the fairer sex in mind, with female as the first party which has been addressed. So everywhere you will see, instead of the earlier legislations where the connotations of he are used, here it is she which is used primarily. Okay. Now with this, let us progress with the presentation. Let's go to the next slide. See, in the area of data protection, it's not that this is the first time something has been done or nothing has been done in other jurisdictions. A number of developed countries have progressed to a large extent, where they have realized that the privacy protection, management, handling, and the consent handling in and around data is of very prime importance. It is with this historical context that in India, primarily the constitution is the supreme law that deals, which is the mother of all the other legislations which flow out of it. We have an Article 21, if you would have all heard of this, which talks about right to life and liberty. At many a times, such interpretations have been given to mean that right to privacy is part of right to life, which is one of the most important fundamental rights, which is right to life and liberty. Now, it was only very recently in the judgment of Justice K.S. Puttasamy that it was finally upheld by the Supreme Court of India that right to privacy is in fact a part of the fundamental right, which is the right to life. However, neither the legislators nor the people who possessed or processed this data were aware as to how exactly can we legislate or how exactly are we going to protect our data. See, for things like physical data, I have this piece of paper or a particular file. Now, in order to protect this data, there have been legislations for a very long period of time. Back in 1923, the government came with a law called Official Secrets Act. So any document which is a secret, which is a government secret, would be having a particular level of secrecy which is accorded to it. However, when we come in the realm of digital data, which is now hundreds and thousands of times more than the physical data which we ever possess, it becomes very important that the person who's giving the data, the person who is the recipient of the data, or at any point, any person who processes that data is cast with an obligation to handle that data responsibly. Not only this, now you cannot simply expect people to follow their obligations or to do things in good faith. So therefore, this legislation for the first time also has provisions to penalize those who violate these obligations. It constitutes a board called Data Protection Board. It also constitutes certain bodies which are the significant data fiduciary. For example, we are all booking flight tickets on a regular basis, or we are going to All India Institute of Medical Sciences for our treatment on a regular basis. These institutions of tertiary care or secondary care, which process and store huge amount of data on a daily basis, are significant data fiduciary, and they have a higher obligation which has been cast on them to handle our data with much more care and caution. Now, these challenges were studied in very great detail by a committee of a retired Supreme Court judge, which is Justice B.N. Sri Krishna. And those of you who have some interest in this subject, I would request all of you to kindly just download that report and go through it. First of all, it makes a very interesting read, but more than that, it also tells us that how unaware we are of this subject, that in so many means or ways, our data gets leaked out. You would have very easily come across several examples. One buys an iPad, and after 2 days, he starts getting messages or links to be shown that how do you buy an iPad cover for that? Okay. Or you buy a nice shirt, it is quite possible that you will get suggestions somewhere saying that how to add it with a good cufflink. Now, it is in some manner a clear indicator of the fact that whatever we do in our day-to-day lives, it is not always that we have to give out that data. Our systems are in such manner, whether you make those purchases on an e-commerce platform or you walk into a particular store, not just your movement, not just your actual buys and sells, everything that you do is actually getting recorded in form of data somewhere. And if it is not handled in an ethical fashion, it may wreak havoc on the society. Now, to address some of these challenges, we have this legislation, and then let us proceed with this presentation which we have. Why data protection matters. Now, I don't need to add too much. All of you know very well data protection is just as important as any other kind of valuable. Uh, we have all had our laws and legislations. Essentially, primarily the legislations protect our life and limb, our physical safety and security. So you have a Bharatiya Nyaya Sanhita or a IPC which deals with if a physical violation is made to somebody. You have economic legislations that deal with the financial well-being of people, that they are not being cheated of, that they are not being there's no financial wrongdoing. You have put money in the share market, nobody is manipulating that, so there are regulations of Securities Exchange Board. You buy insurance, so there is IRDIA. However, when it comes to this never ending generation of data that we do, or the data that gets collected in the process, that data is as valuable as any other form or manner of property that we have. In fact, ultimately, the money that is sitting in your bank account is also a set of data packets only. If you, for those of you who are very interested in the subject and would want to read further, uh, there's an author called Yuval Noah Hariri. You must read him as to how he tells you that all the wealth of the world is actually stored in form of a data. So if you are really serious about protecting the wealth of a state or wealth of its citizen, you must know, or you must have control over handling of data. And therefore, with rising digitalization, with consumer trust and global standards, it became more and more important. It became more and more important that the data that we collect or the data that we give is to be handled in a responsible fashion. Now, as Mr. Damani mentioned very rightly at the beginning of our presentation, that you must do things in the right fashion, whether we are doing the right thing and whether we are doing it in such a manner that those who decide to do business with us, whether we are winning their trust or not. So therefore, a customer will not trust an entity with his data unless and until he is assured that that entity is scrupulously adhering to the principles which are enshrined under this legislation called Data Protection Act. Now, there are global standards that you need to meet. It is not only that we are going to operate in our state or in our district. Now, in such a highly interconnected and globalized world, if you're wanting to do business, let's say you want to do business in European Union or you want to do business in America, you have to scrupulously adhere to their standards, and not only adherence for the sake of it, because the penalties which are being prescribed, which we will have a separate section dealing with them, the idea is that penalties are so forbidding now that a few slip ups may actually cost the very existence of your entity. In fact, that is one of the critique of this legislation, or this is one of the grounds for which people, those who have been upset with this law, have been that they have said that suddenly from a few lakhs or a few thousand, you have escalated the penalty to 200 crores or 250 crores. The very existence of an entity will be wiped out if that kind of penalty is even imposed on them. So therefore, all the more reason for all of us to be very, very careful when we are dealing with instances such as data breaches or data leaks, which earlier were colloquially, general terms which are used in newspapers and media, will now have serious economic ramifications for us. Now, for automobile industry, which are dealing with modern vehicle, you are also collecting sensitive customer information. Data breaches can lead to very serious consequences. You are in the process of sales as well as in the process of service of vehicles, collecting a wealth of data which is to be responsibly handled. Okay, we will get into some of the examples over a period of time, but how to draw consent, how to get consent, in which manner you will take consent, and when will you take consent has now become very important. Secondly, in which manner will you deal after a person has given consent, in which manner that data can be utilized. Earlier there were no yardsticks. Let's assume that you collect the data about the insurance of a particular set of vehicle. Earlier there were very less yardsticks which were there as to how you will commercially exploit that data. Now there is, and the utilization cannot in any manner be contrary to the consent which has been accorded by the data principal or the customer in your case. Let's move to the next slide with this. Now, data privacy, as you can see on the slide here, is essential for maintaining trust in our increasingly digital world. It's a quotation which is at the heart of our presentation, that those who are able to ensure and give this comfort to their clients will only be able to thrive. Now, 3.2 billion record, this shows a significant raise in data breaches. 70% of the compliance failure rate, this indicates a growing challenge for organizations today. You see, there was a time when lockers were being built. There were times when firewalls were being built. There were times when organizations were spending huge amount of money to protect their intellectual property. All that time may be relevant, may be less relevant, but what is of highest relevance today is how you protect and secure your data. Gone are the days that you will be dealing with, floppies and CDs and pen drives to move data from one point to the other. Also gone are the days when you will be simply trusting a common portal like WhatsApp for sharing your customer data with from one end to the other. The manner of exchanging this data or movement of this data becomes extremely important. And the very basis for this law that we are discussing today are these three things. Number one, the Personal Data Protection Bill, which came in year 2019. More importantly, the constitutional framework was given to us by this judgment of K.S. Puttaswamy versus Union of India. It is the privacy judgment, as it is very commonly known as. And then the report of a very erudite judge of the Honorable Supreme Court, Justice B.N. Sri Krishna. He is an expert on this subject, and he has also, you would find his name when you Google that several articles that he has written in Indian Express, educating people about the importance of data protection, about the manner in which organizations need to really pool in their resources to ensure data protection. It is his committee report which has taken the shape of a legislation which we have in our hands right now, which to some may be a very, very difficult change to adapt to. But it's a change that we must adapt to if we want to do our business and earn the trust of our customers. All right. Now, there are these five definitions which assume some importance. Okay. I gave you an example of giving a sample at a lab. Let's take another example of a man walking into a bank in order to open a bank account. Now, I walk into a bank, let's assume for a moment a Bank of Baroda. I give some data, which is, let's say, my Aadhaar data, my retina, iris, thumb impression, signature, whatever data that I have in order to open a banking account. So the person, yeah, we will get into the definition at some length, but the person who is the owner of the data or the person who's giving the data in very simple terms is the data principal. The person who's receiving the data, who's collecting the data, and who's acting and is going to later on act on that data is the data fiduciary. And these are the sections you will find which define what is the definition of a data principal or a data fiduciary. Then there is something called as a data processor. Now, it is not that the bank will process all the data on its own. It may have an agency which will process all the data and will try to arrive at various conclusions. Say, for example, you make a purchase on a platform called flipkart.com in order to buy a white shirt. When you place that order, while you are the data principal and Flipkart may be the data fiduciary, the data will be processed and will be passed on to a third party which will actually act on that order and supply you that shirt or act on that basis. So there may be various other intermediaries who also have been casted with the responsibility of being a data processor. Then data protection board. There is a board or a statutory body which has now been constituted under this new legislation called Data Protection Board. It has not come into being as yet. It has not been established, but it is on its way. We all know that it is coming. And mind you, all my friends, that this body is going to be one which will have substantial amount of powers which you have not seen, which we have not seen in civil legislation for several years or decades now. The kind of penalties that they can impose, the kind of inquiries that they can do. Those of you who have had experience with some of these criminal investigating bodies in recent past, if any of you have handled matters of, let's say, enforcement directorate or income tax, mind you, this is going to be no lesser than that, because the expanse of the power which has been conferred on them as to what all they can find out from you voluntarily or by way of invasive methods. Data Protection Board is one body which is going to be of highest importance. And it's going to be my suggestion to all of your managers, general managers, senior managers who are dealing with the legal issues, that Next time a notice comes from the Data Protection Board of India, kindly don't throw it inside your drawer or dustbin. Accord some importance to it, because in the future slides that we are going to discuss, it may have some very serious civil ramifications on us. And then there is significant data fiduciary. So significant data fiduciary is a different class of data fiduciary. Let's say I will be a data fiduciary if I am running a dealership. I'm collecting some information in the course of the sales that I execute or the service that I give to my customers. But that may still not be significant. The central government or the government of India has been given with this power, has been entrusted with this power to notify certain data fiduciaries as significant data fiduciaries. For example, agencies which will collect a huge amount of data, let's say big hospitals which are there or airline companies are there. Okay. Now, these will have data which is going to have implications everywhere, and therefore a higher responsibility has been saddled on them to be more careful. And not just that, they have been cast with a responsibility to have an internal data protection officer who will ensure scrupulously the compliance of this entire legislation. And therefore, they also need to do an audit on a regular basis. They need to do a data impact assessment to find out as to whether the manner in which we are dealing with our data is whether that is safe, whether that is being done as per the provisions of this act or not. However, our dealers are not going to be within the category of significant data fiduciary, but you are certainly a data fiduciary. Okay, some of the automobiles companies may or may not become a significant data fiduciary, but dealers will not, because our numbers are so heavy and we are more into the retail transactions. And then there are categories on which a particular entity is to be notified as a significant data fiduciary. So if you look at the law has various yardsticks on basis of which the government of India may notify a particular body as a significant data fiduciary. And those elements are volume and sensitivity of personal data that is handled. So for example, banks are having or handling a huge volume of data in terms of transaction, in terms of the data that come to them, the risk of and the rights of the data principle. Okay, so if the risks involved in handling the data is very high, then it is going to be classified as a significant data fiduciary. Then potential impact on sovereignty and integrity of India. If the protection or the integrity of the union or of the state is under is could possibly be under threat because of some data fiduciary, that will be cast with a higher responsibility. Security of the state and public order. Okay. So section 10 of the new legislation deals extensively with this particular thing, which is significant data fiduciary. Now, with this, let's go ahead to our next slide to understand what all is there in this law, which are the key features of this act. Now, first thing, and this I would want everyone to pay some attention to, because this is something which will be of importance to us. Earlier, we were getting data from people. We were, in very simple terms, we were collecting data from the data principal or the owners of data without having to seek their express consent. You would have all downloaded applications on mobile phones. They sometimes do, they sometimes do not uh, seek consent of what they're going to do. So, for example, they seek consent that they're going to access our images, they're going to access our contact list, they will access a particular set of things from our phones, and those are the permissions which you are granting, sometimes knowingly, sometimes unknowingly. However, the times of those unknowingly giving permission or unknowingly taking permission is unfortunately gone. Now you cannot seek all this data. Say, for example, you are seeking the customer history about his name, his age, his financial condition, the last 3 years income tax records, other material, his driving license, his other documents are being sought, basis which you are finally giving him a quotation, or you are processing his documents for granting of an insurance policy to him, or for a lending transaction or a loan which is given. A very express Consent terms have to be signed by every entity which comes into your premises and parts with any amount of data. And that consent based form or the consent based processing is at the heart of this law. It basically, in very simple terms, says that you cannot accept any data without his express consent. First line. Second, whatever consent you take, you must use the data for that very purpose. So you can't say, let's say that I am collecting this data for issuance of policy to you or for suggesting some insurance policies to you, but then you cannot sell that information to a third party for doing a after sale call to him. Okay. You cannot collect data. Let's say a hospital cannot collect data for saying that I will use this for treatment, but that is being used for a different kind of a research on a particular kind of patients. So the at the heart of the new legislation is consent, and the consent has to be an informed consent. You need to be told, or you must inform and then speak and then obtain specific permission as to why do you need this data and in which manner will you use it. Now, my dear friends, this will require some bit of changing the ways and means in which we do business. Our forms, our formats may not be aligned to this consent based processing. We might be relying on very general terms. I hereby consent to all the terms and conditions of the dealership which is there, okay, or of a particular manufacturer. Such clauses will not work anymore. You must have a very clear and unambiguous form in which you will say that we are going to collect the following items of your data and we will use it for these purposes and for how much period of time. It cannot be an endless exercise. Secondly, if you have already collected some data, which you would have over a period of last 5, 10, 15, 20 years, and you still want to put that data to use, whether you want to utilize it for your own commercial benefit, you must now seek consent of that earlier customer. Now, all of you will tell us that that will make life very difficult for us for a very simple reason that now instead of focusing on doing business, we will have to focus more on obtaining consent from our customers. And every time we will have to spend more energy on explaining to them as to why we are collecting data, which was something which was happening in a very automatic or a unnoticed fashion at the earlier point of time. Let me remind all of you, it is this consent which has to be taken at the time of collection of data or prior or before collection of data. It cannot be after collection of data that you will be able to utilize this data. If a single customer lodges a complaint that his data has been collected, and God forbid if he lodges a complaint that is being utilized without his knowledge or without his consent, you will have a good number of questions to answer before the digital protection board, the data protection board, which is there. Okay. And God forbid if any of that data gets leaked or becomes part of a data leak or a data outage, then we will be in greater difficulty because there are other violations which are in place, which we will have to then explain as to why this happened. Why did we not seek consent? If we sought consent, in what manner did we seek consent? Okay. Now, there is a simple uh, explanation which is there in the law itself. So, somebody asked me in an earlier seminar that, sir, can we tell people that we are going to collect your data about the usage of the vehicle, the usage of the accessory, and so on and so forth, and add a condition there that tomorrow, in case of a data breach, no case can be filed against the particular dealership. Now, see, that idea may look quite tempting to us that we right now only take a declaration from them that you will never be able to file a case against us. That's not how it will work. This has been specifically cut down under the law, which says some hospitals also tried to have this kind of conditions in their disclaimer formats that we are collecting the data which may be used for research purposes, for the commercial purposes, for future customers and providing them better services. And no cases can be filed for data breach against us ever in future. This clause will certainly be struck down by the court because such a clause cannot be inserted in any contract, which will say that if you cannot go against me for a data breach. Next is data minimization. Now, you see, while storage of data was easy and more accessible and was possible with lesser amount of expenses, we were in a realm or a world where we were collecting every kind of data. Sometimes just for keeping it to be used at a future point of time in case the requirement arises. The new regime frowns upon this practice of collecting every possible kind of data. It is focused on data minimization. You must collect only what is required for a legitimate business purpose and by legitimate means. Okay, so an information has to be collected only with the consent and has to be used for legitimate purposes. Okay, you cannot be selling the data of a customer without his consent. You cannot be passing on data to a different entity. It can't even be a sister concern of yours. You can't say that we have had a MOU with our sister concern for last 30 years, and every data which comes to us we keep on passing to them. No, you cannot do that. Okay, so with these three things which are at the heart of our legislation, let us move to the next head, which is individual rights. The right to access, correct, and erase the personal data has now come in, which gives a person a right to now come back to a party or to an entity where he has given data. Let's say I go to buy an insurance policy and I need to make certain disclosures to the insurance agent at the time when I'm buying the insurance policy. Now, an insurance policy is a policy which is based on your full and complete disclosure. You will make statements that I have, let's say I'm buying a life insurance policy. So I will say that, I'm a teetotaler. I have never had a disease. I have never had any problem. Okay. Now, when you give all this data basis that you will get an insurance policy. However, that information can certainly be used only as per the consent which is given, which is for the purpose of issuance of policy or for some legitimate purposes. Okay, a person can always go back 3 years thereafter and say that you cannot use my data any further, kindly delete all the data. You will have to, under the new regime, we will have to, as the dealerships, ensure that we are in a position to agree to such requests and tell that customer that yes, we have noted your request. We are removing your personal data from our records, from our hard drive, from our storage systems, so that the person has that assurance that his data has been erased, corrected, and he has a right to access the data which is there. You can go back to your hospital even after 5 years, even after 3 years, and ask for what data which is there, what treatment was carried upon you, what surgery was carried upon you. And therefore, this regime of individual right has been created under the new law. Earlier, there was no accountability. There was a Right to Information Act, but that did not apply to every and any venture which was there. Now, under the data protection, the information which is stored in a digital format. Now, let me also remind all of you, Data Protection Act deals with the digital information. The very law starts with the word Digital Personal Data Protection Act. Okay. So anything which is stored in paper and files and this and that is not what we are discussing right now. So a regime is being created under which the individual rights have been strengthened, where people are entitled to modify, erase, and correct their data. Then it also allowed, but the government may restrict transfer to certain countries, cross-border data transfers. And then data fiduciaries must implement security measures and appoint a data protection officer and conduct data protection impact assessment. You see, this will not concern us as dealerships or entities which are providing after sales services. But the significant data fiduciaries have been given a responsibility, number one, of having data protection officers. There'll be a dedicated data protection officer, and that data protection officer, like you have your legal manager, cannot be reporting to the general manager. Okay, the data protection officer must report directly to the board of the company. So the data protection officer has been given a rank which is either equivalent or just below the board of directors, so that tomorrow nobody can say that, sir, my data protection officer informed his senior, who informed his senior, who also informed three of his seniors, and the matter never reached the board. It is expected in case of any significant data fiduciary, that in case there's a breach of data or there's a breach, then the company can directly be held liable. And then there's no glass ceiling which will say that a junior level officer is the one who's responsible. Okay. So with this accountability which has been fixed and a duty of data protection impact assessment, the entire subject matter is going to change. Now people are going to be much more select in terms of what data they collect, how they process it, and how casually sometimes you would find that the data breaches happen. Because even if in 1 dozen cases the data protection board implements its orders and imposes the penalty that it has been authorized under the act to implement, then I'm quite sure the instances of data breaches will settle down, will lessen over a period of next few years. Okay. Okay. Now, Data Protection Board is one agency that all of us must watch out for. This has been specifically created under Section 19 of the DPDP Act to oversee the enforcement of data protection regulations. Functioning as an independent body, it operates with the powers of a civil court. That's what I said. While many agencies have the power of acting as a civil court, the kind of penalties and punishments that they can inflict on a particular agency or on a particular company is very widespread. Now, with this, let us look at their functions, which is broadly, it is to investigate. Let's say today we have gone to a hospital, or we have gone to an educational institution and given some data about my past. Now, we feel that that educational institution has not been very diligent with the data that I have given, and that data has gone out in a leak. And basis that data which has gone out in a leak, I am getting various calls. Let's say I was in an institution where I only scored 45% in my undergraduate. The postgraduate colleges know that this man will not get admission anywhere, but that data gets leaked out. Now I start getting colleges from all postgraduate institutions saying that instead of 12 lakh, you pay me 17 lakh rupees as the fees and I will give you admission. There's a basis to assume that my data has leaked out. What is the remedy that I have? I will go and lodge a complaint with the data protection board. And I will say that, sir, my data has been compromised with this agency and therefore I would want you to investigate. Let's say we have a customer who has purchased a vehicle from you. It has a tire of Bridgestone company or of any company. The vehicle has run for 7 years and the tires are now almost at the end of their life or at a position where they would require a replacement. A list of all customers who purchased vehicles from your dealership 7 years to 10 years ago gets leaked out to an agency or a person who's selling new car tires. And he starts making calls to everybody that, sir, 7 years ago, you purchased one vehicle from Mr. Jha's dealership. Now you must be needing tires. So I'm offering you tires at a 25% discount. The man will get shocked as to how my data is reached a random person who did not even know about my car, who did not know my mobile number, and now he knows everything that I have, right from mobile to email ID to Instagram ID to everything. That person can simply go to a digital protection board and lodge a complaint against you or lodge a complaint against such an agency. On filing of the complaint, the agency, which is the data protection board, can start an investigation, a preliminary investigation in which they will call for your statement, they will call for your responses, and basis which, if they come to the conclusion that there has been a breach either by the data processor or the data fiduciary, then they will impose penalty on you. And then there is an appeal mechanism which is there. So a data protection board's order can only be challenged before an agency which is based in Delhi or a court which is based in Delhi, which you would not have heard too much because you're not in the telecom domain. It is called the TDSAT, Telecom Dispute Settlement Appellate Tribunal. That has been given the power to hear the appeals under this particular law also. Okay. So, and then the orders of TDSAT finally go to the Supreme Court in case somebody is still not satisfied with the orders. Now, let us look at the penalties which are there under this DPDP Act. Okay. I want to show this presentation, but before I show this presentation, I want to show you a particular slide and I would want to show the schedule which is there under the Act. I'm just halting the presentation for a time being. And I invite all of yours attention to the schedule, which is under the new legislation. Uh, Saharsh, if you are able to see, okay, this is there on your screen. Widen this kindly. Now, this is the penalty which is proposed, and I want to read it for your benefit a little bit. Breach in observing obligation of data fiduciary to take reasonable security measures to prevent personal data breach under subsection 5 of subsection 8. You see, this can be of a set of people or an individual also. This is for failure to take reasonable security safeguards. This may extend to 250 crore rupees. Now, it may be a lesser amount also, but see the quantum of penalty which is possible. The second is breach in observing the obligation to give board or data principal notice of a data breach. So if at the very beginning of the presentation, what Mr. Damani said, that did you know that now you have an obligation to inform your customers or inform the data principal or the data protection board in advance from your end itself, that sir, there has been a data snag at my end. That customer data which I had stored for last 3 years has suddenly gone missing. Somebody has either taken a backup. Failure to comply with that may lead to a penalty which may extend to 200 crores. Next is breach in observance of additional obligations under section 9 relating to children. Now, my dear friends, this may not pertain to us, but it is good to know this, that children, which is a specifically vulnerable category of customers, have a special protection under which if their personal data is being used or misused at any particular place, then it may lead to a higher penalty, which may extend to 200 crores. Breach in observance, this is the item number 4, which is breach in observance of additional obligations of significant data fiduciary. For example, failure to appoint a data protection officer. For example, failure to carry an annual audit or an impact assessment. This may lead to a penalty of 150 crore rupees. Breach in observance of duties under section 15, and breach, next is breach in terms of voluntary undertaking accepted by the board. Now, these are all, nobody is talking here in thousands and lakhs, as you can see. Let's go back to the presentation. What I wanted to convey was that the quantum of penalty which is now contemplated under this legislation has now gone to a different level altogether. We are no more talking about penalties which a consumer court will impose upon you of a 5 lakh rupees or a 20 lakh rupees or a 30 lakh rupees. We are considering cases where the penalties could go up to 200 crores. Now, some of you may ask that I don't even make 200 crores in 3 years or 5 years of my business. What if I get visited with a penalty like this? Now, you see, this law, these are the critiques, or this is the criticism of this law, that when you don't distinguish between an offense of pickpocketing and an offense of murder. Okay, something which is getting punished with a 250 crores must be the highest level of violation which is there. Okay, this also exposes the law for misuse by officers by data protection board. So tomorrow, if some officer or the adjudicating person who's carrying out this function may threaten you that if you don't comply with our directions or maybe whatever other considerations, there may be a penalty which may be this high. And the very existence of our dealership, our companies, or many mid-tier companies will also be wiped out if you have to provision for 250 crores in your balance sheet for some penalty which has been slapped, or even a show cause notice has been issued where the penalty could be 200 crores and your auditor has to make a disclosure that this has a contingent liability of 200 crores or a 50 crores. That is a very, very serious implication. And therefore, we must keep in mind something, and which is what we tell a lot of our clients, that just because there is power does not mean that it will be exercised in that fashion. Just because a violation of not keeping security measures has a penalty of 250 crores should mean or would mean that there will be a penalty of 250 crores on me. Let's assume a simple example. A person goes and opens his bank account. His ATM pin gets compromised. Okay. Or in the process of delivery of his password, online net internet banking password, that gets compromised and comes in the hand of a hacker, and there is a data breach there only pertaining to one customer. Should there be a penalty of this heavy amount? The answer is, and of course, no, it cannot be. However, this law basically functions on the principle of how to how to place deterrents in front of people who are acting as data fiduciary, so that they do not take a lax approach. They do not take a easy approach that, all right, we will deal with the data in our own fashion. If there are some breaches, then we will deal with them the manner in which we deal with a traffic challan. It is not like that. It is something which may have very serious implications. Okay. Now, uh, for example, there's one violation of failure to obtain consent for data processing. If you don't take that consent, you saw the kind of penalties that can be imposed. Inadequate security measures, non-reporting of data breaches. Earlier, there were no such obligation that you will report if the data from your office has been misused, or some unsatisfied ex-employee has breached the data and given it in the public domain. Uh, for which has led to a data breach. Earlier, there was no such reporting obligation, and certainly there was no such penalty which was prescribed. All that has changed, unfortunately, now. With this law, it basically expects us to be diligent at a different level altogether. Okay, let's go to the next slide here, what we have. Okay, now what are the precautionary measures for us to ensure that we do not land up, or we do not have a hearing before a data protection board or a TD SAT for handling these show cause notices? See, the rules are yet to be notified. So once we have the rules in place, we will have another session where we will discuss as to what exactly are the formats, registers, or the disclosures, or even the consent forms that we need to evolve. But for the time being, it is very important that we maintain a digital record of all the personal data that we collect, that we process and store. We have a very clear system, and preferably an online system of consent management. You must be having system for recording attendance. You must be having inventory management softwares. You must be having various kinds of softwares. In that software, you must now add in a new tab or a new head for consent management. Companies like mobile companies, big data companies, they are already having this consent management, and they deal with it, they grapple with it. In several jurisdictions, they also face a lot of penalties for not taking informed consent. Many a times you will simply, just do I agree, I agree, I agree everywhere. Of course, nobody reads those terms and conditions. But now that has changed. The consent cannot be simply asked by saying that you read a 2000-page form and then basis that you will know. I am obliged now to explain to my customer that if I am taking his financial information, if I am taking his income tax returns for last 4 years, how am I going to use that, and for what purpose it will be used, and what am I doing to ensure, what are those security measures that I have put in place to ensure that that data is encrypted, is kept under firewalls and secure servers with regulated software updates, so that there is no breach. Of course, there can still be breaches thereafter also. You would have heard that Government of India websites are getting compromised. The website of a particular ministry has been hacked. So there will always be people who will outsmart us, or who will have more focus on these destructive measures. But if we are able to show that we took all reasonable measures, just because a man had an accident does not mean that he was not careful enough. But if a dealership is able to show to the data protection board that, sir, in last 3 years, we have spent 5 lakh rupees in ensuring that our firewalls are in place, we run on secure servers, those who are allowed entry are based on a 3-level authentication, the data cannot be downloaded. So if we are able to demonstrate those security measures, then we have a very valid answer. We have a basis to defend a claim for data violation or a data breach. All right, let's go ahead. Next is employee training, which is very important. See, data handling without employee training is like walking on a highway with blinds on your eyes. Okay. You can't expect that you will only hear lawyers and know about the penalties and know about what is the definition, and then you'll be able to implement it. It must trickle down. It must trickle down. You must be instructing your staff at every possible level as to how to handle with customers, how to handle with the method of their payment. Your customers must not be allowing people to drive vehicles without having proper licenses, right? In same manner, a basic level of data protection training must be given. It can't be that your customers will obtain a RC or an income tax return or a particular financial information from a customer and then would not know about how to handle how to handle this in accordance with the Data Protection Act. So I would urge all of you to put in your efforts for employee training purposes. It is only a simple half an hour, 45 minutes training in which they will understand the broad corners of this. And you see, these trainings also get recorded so that tomorrow, when there is an audit of yours by the Data Protection Board, you are able to show that, see, I have hired this KPMG for the purpose of training my staff, so that they understand that, yes, you took measures which were within your control to sensitize your employee, to sensitize your finance team, to sensitize your sales team, that these are the measures that we need to take into account. And next is third party audits. Okay, let's move ahead. We are now almost at the end of our presentation. See, measures a dealer should take in case of a data breach. See, assuming that there's a data breach, unwillingly, your data has either been stolen, leaked out consciously, or maybe just an employee who's not too happy with his management simply puts it on a dark web or puts it on a public domain. Okay. How do you deal with such a scenario? And a lot of questions we have received around that. This legislation will essentially attack you from all sides in that scenario. If any of the data principal get to know that his data has been breached in this fashion, then an inquiry will ensue, as I said, and it will go before the Data Protection Board. Your immediate response should be, of course, to identify the source and extent of that breach. This law is not a replacement of ordinary criminal law, let me tell you. An FIR would still have to be lodged. A complaint would still have to be lodged with the police authorities. But in addition to that, the report of breach also must promptly, as early as possible, must go to a data protection board, which is constituted under this act, in which, after your internal assessment as to how much data has been compromised, what category of data has been compromised, from which financial year to which financial year has been compromised, you must give them a report. And it is a very standard practice that they will initially ask for write-up from you, and then basis that they will depute people. You must inform. Now that becomes important, and that is something which is a tricky area. People generally don't want, see, I have closed a sale 5 years back, I've closed a sale 2 years back, or a service program which I ran 3 years back, and there has been a data breach. You must be in a position to inform those customers either by way of electronic mail or by way of a SMS, to inform them that what breaches have happened and what steps are you taking. This looks like actually stirring it causing a stir in the entire scenario. A customer who would otherwise not know would come to know about it. But let me put it to you the other manner. It is an obligation on you to inform those customers whose data has been breached. So if you don't inform them first and they get to know about it from any particular source, then they don't need to be 50 people. Only one person can go and lodge a complaint, and that will sort you out. Okay. So it's important that you also, evolve methods by which you will do this, what is called whistleblowing activity, by which you will inform these people. Okay. Next. Investigating and remediation. As I said, this law is not a substitute of ordinary criminal law. What you will do under BNS or the earlier Indian Penal Code, informing the local police station, informing the places where your servers were based or where your ordinary place of business is, that such a data breach has happened, what is the possible source of it, and conducting an internal thorough investigation to find out the cause of breach. Many times police authorities are also ill-equipped to handle with this data protection related subject. They are themselves, their hands are more than full dealing with ordinary and day-to-day crimes. So you will have to educate them, you will have to help them. We've had various cases where bank information has been leaked, DSA agents have leaked the information, or the information has unwillingly gone out because of some employees not being very diligent with the information. It is very important that you simultaneously also start working with police authorities in this. And next is documentation. Make a detailed documentation of the breach response action. You see, documentation becomes important because when the matter is going to be ultimately decided by the Data Protection Board, they will be hearing the matter 3 years after when the incident has happened. And they would actually want to see what you did. For example, let's say a patient has gone to a situation where he's almost about to die. Every minute what treatment is given to him, it may be a private hospital or a government hospital, is recorded in the clinical notes which are prepared by the hospital. That first, this particular drip was given, then this medicine was given, then he was tried to resuscitate, then we shifted him to the operation theater. We did these 10 measures and still we could not save the patient. If your response to a data breach is documented, then that gives us good talking points in front of the data protection board, and we will be able to defend an action, because everybody knows that even a national informatics center of government of India cannot guarantee that no data of government of India will be breached. So therefore, if you are having proper documentation of what steps that we have taken, we have certain grounds to defend. Let's go further. Okay, so this brings us to the end of today's discussion. I understand it's a Friday evening, data, and so much of data has been spoken about. But if I have to sum up this entire discussion under a few heads, the points will be: number one, data is certainly of the highest importance. Consent is at the heart of this legislation. We need to earn the trust of our customers. And lastly, if there is a breach, then please try to contain it. Brushing it under the carpet will not work. And lastly, and most importantly, try to train your employees. Like you invest your resources in training people in how they can become good salespeople or good service people. Give them a basic level of understanding of handling and protecting data and being careful with it and not dealing with it on a normal WhatsApp or a normal sharing program services. It has to be exchanged in a secure climate. Now, with all that in mind, if you any of you have any questions, I'm very happy to answer, Saharsh.
Anandji, thanks a lot for such an eye-opening webinar session, what we're doing right now. Uh, I think it has broadened a lot of views for us, even though the law is still in the draft format.
Yes.
I think it's a good step that we're doing this webinar and educating our members. It's basically a stitch in nine saves, a stitch in time
Yeah,
saves
yeah.
nine kind of.
Saves you nine, absolutely.
So we have few questions with us. I think Mr. Sukhbir Bagga is asking, in the beginning of the session, you shared some author's name. So can you share the names and the title of the books?
Yes, yes, I will share. Yuval Noah Hariri. I will put it in the chat box if I can. Dal do usko.
Sure. Okay. Mr.
And
Sheel
I'll,
Mir-
I'll I'll suggest you that book also that you must read.
Mr. Sheel Mirje is asking, who will do data impact assessment? Is it a third party audit?
So, data impact assessment is at present required only for significant data fiduciary, and it will be a third-party audit. You are right. Agencies like KPMG or PricewaterhouseCoopers, they are building the capacity to do data audit. There are data scientist firms which are operating in various jurisdictions, especially you would have heard Switzerland, Liechtenstein, America. There are various data science companies which are coming up, which are also equipped to do that. But I don't think our dealerships are required to do the audit just now.
Okay. So can a director be data protection officer?
Yes and no. Yes, because of course the man has to be closest to the board of directors and answerable directly. No, because I would not want a director to be made responsible. An officer must be there who would directly report to the board. You don't want the queen to be compromised on the first move.
Okay. Do we need to have an agreement with team members who are handling our data?
Yes, in fact, you would also want to make certain changes in the employment contract if you can do that, because ultimately, 8 out of 10 or 9 out of 10 breaches happen at the end of employees only. The management never really gives a green card to them that please, deal with the data you wish to. So you must have employment related conditions that they are, I mean, like you say, no, that behaving properly to the staff, other staff, or diligent in terms of financial dealings is a non-negotiable point. Similarly, data protection is a non-negotiable point. If you are found to be participating unwittingly also in breach of data, that must be a good enough ground for your exit from the company. Okay. So an agreement with them in form of an employment contract, a disclosures at various places in your office, all those add up to the protection that we can develop.
Okay. Can this consent be part of invoice or other documents we ask customers to sign before delivery and or OTP based recorded digitally?
The consent cannot be a part of an invoice. It cannot be a terms and conditions written on the back or at the foot. It has to be a dedicated express consent form. Okay, about what data. So typically you will have to evolve a format as to what all data we collect as a standard and how we intend to use that. That cannot go towards at the back. It has to be a separate format, and me and you, we need to work together to evolve that format. And then of course we need to roll out it to our members so that they can adapt it as per their requirement, but that's an activity in itself. I would actually want to assist you in that process to evolve a format, so which we can give as a broad guideline to our members. Okay.
Will do. How can a customer claim that the breach data is from a particular source?
Customer can only make an allegation, and you are right. He cannot claim, or he cannot simply pinpoint that, Mr. ABC's dealership has lost my data, but he can lodge a complaint and then follows the investigation by the Digital Protection Board. So if in that investigation it comes out that the leak happened at our end, then we are in trouble.
How much time do we have to set up the data protection infrastructure after the law is passed?
We are all running against the time. The legislation is yet to come into being, but I would ideally want that by the time we begin the second quarter of this year, we must have certain compliances in place.
Okay. The consent should be on paper with a written MOU signed, or it's required to be digital.
It can be digital, which is just as good. It can be OTP based, which is just as good. It must have clear radio buttons and clear heads to be accepted. It can't be that I have read a 3,000 page consent forms. Give a clear, specific, comprehensive form with 8 or 10 heads. Okay. And as I said, we need to evolve that. We need to evolve that. It is not in existence in India today.
Hmm. So now there's $1 million question coming. We are all fighting that this data belongs to us. So who owns the data of our customer? The dealer, the OEM, the financer, the insurance company, or the transport department?
The answer is data principal, the person who has given the data in the first place. So you are not the owner. See, the term used is of some importance. Data fiduciary. Fiduciary means there is a fiduciary relationship between the person who's giving the data and you. He's trusting you with the data. Okay. So as a fiduciary, we are accepting the data and we have certain obligations. So it is certainly not our data. It is customers' data. I have certain obligations to keep them in a particular format. Okay. So
And
therefore, a customer can come 3 years down the line and under this new law say, erase all my data from your system. And if you don't have an outstanding from him, if you don't have a dealing with him, you have to delete that data.
and the follow-up to this is who has the onus of protecting customer data?
The customer fiduciary, us.
Yeah. So there's a question. We are an automobile dealer and have to collect customer information, which is shared with the RTO, finance company, insurance, FASTag company. In case of a data breach, how can a dealer be responsible?
If the data breach happens at your end, then
Hmm.
of course you are responsible. If the data breach, let's say, happens at the end of FASTag agency or the insurance company, see, as I said, data fiduciary will also have other data fiduciaries or data processors. So if the breach is at the end of the data processor who's processing that leg of data, you are only an intermediary. You are passing the insurance information to, let's say, a national insurance or an ICICI or Lombard. If a breach happens at their end, they are responsible.
And we need to understand it's a Digital Data Protection Act. So the leakage happening at whoever's end on the digital in the digital pipeline, that's where the onus comes in.
Yeah, that's where the onus comes in.
So how do we deal with advertising agencies from whom some data is purchased in form of leads? Do we need to have an express contract with them?
That's a very, very important subject. The term used under the law is using information for legitimate purposes. There is no guidance under the law to mean what is legitimate purpose. Legitimate purpose can be, of course, getting leads and then exploring those leads to turn into actual sales. Okay. But to what extent that is there would also depend on how pure is the data that they have collected and what good sources they have. Let's say I am doing a search on a particular website and I get interested in a particular vehicle which gets generated as a lead. The entire chain of information gathering has to be sanitized in terms of contract. We can only do it by way of contractual disclaimers, by which the entity from whom we get this data, we must clearly put in place the rights and obligations as to how they have procured the data and in which manner we will use the data. Okay. For how much period we will use the data.
Sheil Mirjeji, yes, we can't use the same data to upsell future products. It's very clearly mentioned. The data has to be used for a very particular kind of requirement only. Can we ask insurance company, finance, etc., that data we give can't be used by them?
See, the data that we give to the insurance company, see, at the time when let's say I'm taking 4 years financial ITR and I'm passing it on to a finance company for processing a loan, the consent will clearly say that I am collecting this information for sanction of loan only. Okay. And that is the purpose, loan, comma, insurance. So it can be used by them for that principal purpose of granting or not granting a loan, but nothing beyond that. They can't then go on to sell that information.
Yeah, I think we are done with the questions, but more importantly, we're just scratching the surface at this point of time.
You are right.
Work has to be done in terms of training of staff, in terms of getting yourself trained first, developing your infrastructure,
Yes.
creating the documents which needs to be signed by the customers, and all those stuff has to be done. And definitely we'll work with you on this, Anandji. But
Yes.
thanks a lot for handholding and for sharing your insights into this act, which is still in the draft mode. But
Yes.
very important for all our dealer members to understand the importance of this law and get prepared, because I'm sure a lot of litigations will fall into place. People may do it just for fun, just for creating havoc, just for,
Yes.
getting out some money from the dealership, that my data has been stolen or whatever. But it's very important for all of us to, get ourselves updated. I have also shared both the documents, the gadget notification and a brief understanding in the chat box, which can be downloaded by all of you. So, being Friday evening, I think it's time to wrap up today's webinar. But
Yes.
sure,
Thank you very much.
once the law is framed, it's enacted by the Act of Parliament, we'll again huddle and see what are the final laws and
Correct.
how do we take it up. With this, thanks a lot for joining for today's insightful webinar. Have a great weekend ahead. Good evening.
Thank you.
Thank
Thank
you.
you.